How does Arizona define sale, possession, and trafficking of drugs? Attorney Laura Killham explains that. There are many factors that determine if a person is charged with possession of drugs for sale or trafficking of drugs. One factor considered in the statute defining sale of drugs is the amount in possession of the person. Additionally, the statute defines transportation or trafficking drugs as importing drugs into the state or offering to transport drugs for sale. Possession of a dangerous drug is a Class 4 felony. If a person hasn't been previously convicted of a felony, then an attorney may be able to file a motion with the state to reduce the charge to a Class 1 misdemeanor with probation. If you're charged with anything under a Class 4 felony, you may receive the maximum punishment of 3.75 years in prison, 4 years of probation, and a fine of $150,000. If your charge is reduced to a Class 1 misdemeanor, then you can face a reduced sentence of about 6 months in jail, a maximum of 5 years probation, or a $2,500 fine. A person shall not knowingly possess, use, transport, distribute, or manufacture marijuana. The criminal consequences of possessing marijuana depend on quite a number of factors, including whether or not you have prior convictions. Under the statute, if you're in possession of 2 pounds or less of marijuana, then you can be charged with a Class 4 felony. On the other hand, if you are in possession of 4 or more pounds of marijuana, then you would be charged with a Class 3 felony. The state sometimes allows for a deferred prosecution in possession of drug cases, but it will depend on whether or not there are prior convictions. Contact attorney Laura Killham for a free consultation in Peoria, Arizona today. While many defense attorneys have prosecutorial experience, Laura's in-depth knowledge and experience allows her to obtain the best results possible.